Was there something we needed to do before the jury came back? What do we do now? Yeah, please go over there.
So the court issued a suppression of some flyers in the defendant's vehicle in the order from August 1st of 2019. I've discussed it with Mr. Moran. My understanding is he's not going to put in the flyer that was found in the folder, which is specified by the court. The court didn't specify about the similar index cards that were the same thing inside a packaged area as well. We had interpreted the analysis to mean that both were suppressed. If both were suppressed, we would ask that the defense not introduce them. I would acknowledge that the order is not explicit as to the index cards, but talks about flyers of Dylan and refers to a folder.
They're all recovered from the same spot, right?
Generally, but not exactly. And I can approach with the two photos. One's in a folder and one's in a boxed envelope. May I approach?
Yes. And you guys are going to have to help me with what happened here, okay?
In the order the court
in the folder, I remember specifically anything in the folder I said couldn't come in.
Exactly right. And so
I didn't know, either I didn't know or I didn't remember. I don't remember about the cards.
Right. So we relied upon that, not putting it in our case in chief. If we misunderstood the court's order, then I understand why defense counsel would be able to put them in. The court's orders from August 1st of 2019. I had thought the court meant none of these flyers or various things are coming in.
Well, where was this little box taken from?
Inside the truck, and I'm not exactly sure from looking at the photographs.
So you don't know it was out of a briefcase or?
No, I don't think it was out of a briefcase, but I don't want to speak with certainty. So either way, Judge, I think there's a 403 analysis as well. There have been objections to these flyers coming in at different points in the case. The biggest example was at the vigil and flyers being passed out. We don't think they have much value under 401. Based on the court's ruling, we would ask the court that these not be admissible, but I acknowledge that the court did specifically say in the folder. Part of it is that we don't want it to be suggested that we didn't put this into evidence. And if that suggestion's not made, it would alleviate the concerns. We were relying upon the court's ruling.
Mr. Moran, what are you thinking about putting in 1093 or what?
I'm going to really struggle to not use the language of specious. One, with the suppression, that would mean that we're the gatekeeper of that information. If we wanted to introduce it, that would be something the defense would have druthers to do. Second, the prosecution has elicited repeatedly from witnesses that Mr. Redwine was not interested in the disappearance of his child and that he wasn't engaged in the efforts to find him. That would be rebutted by the items of evidence that Mr. Redwine had printed up that he was handing out to friends and other people who were well-wishers and otherwise.
Well, hold on. Let me ask you this. Ignore the cards for a second. You guys moved to suppress this evidence?
We not the box, but
you moved to suppress the search of the truck. This is from Whatcom, Washington, correct? Am I remembering right?
This is from the Dodge, Judge. This was
it's from the Dodge. I'm sorry.
Yes.
So yes, and I mean we moved to suppress most of that stuff, and I should probably have this framed on my wall because we won one, and I think it was Your Honor's order about the items in the folder being outside the scope of that particular search warrant. So yes, and I'm not going to seek to admit those, though I think that we probably could. We'll save that discussion for another day. 1093, the box-like envelope is in fact a box, and the items in it were in plain view. We intend to introduce those. The envelope or the folder, the file folder, was the subject of Your Honor's order. So without reaching the issue of whether the defense could introduce something that was seized from Mr. Redwine outside of a search warrant, whether Mr. Redwine could choose to waive that particular impediment.
I'm not saying you can't choose to waive it. We don't need to argue about that. I'm just thinking that opens up probably the rest of the search, and I don't know what effect that would have.
We're not going to introduce the contents.
Fine, so we don't need to talk about it.
But the box of cards that have Dylan's face on them and say missing teen, that's.
And when are we planning on this coming in? What was the thought?
Kevin Torres from the Colorado Bureau of Investigation did or helped with the search of the vehicle. He was present when things were taken from it. He was there when luminol and phenolphthalein testing was done on the
That
places.
wasn't my question. When are you going to try and introduce
Beg
it?
your pardon?
This afternoon?
Today.
Okay, that's what I needed to know.
Sorry.
So after this next witness?
Yes, sir.
Okay. So
Or 2 witnesses from now.
So I need to do a little research. That was my question, so I could know what was going on. I'm not, if I didn't suppress it, I would think they'd come in. If it's part of the same search, I don't know. I'll have to go back and look at my order. I'll have to go back and look at the motions. I'll have to go back, and I don't know if I can at this point. Do we have the returns on the motions?
The returns are attached to defense counsel's motion.
Okay.
And
And this was, the cards were talked about in the returns? Did I just miss it?
No, they're not in there. That's part of why I'm asking for guidance. I think I've been transparent with Mr. Moran about this, and I'm being transparent with the court. I think that we just don't know about the cards. So the court actually suppressed multiple items in there that were in envelope type things, and these cards were as well. They're just not explicitly addressed. So I understand either ruling, Judge. I'm just asking for the clarification. I think with the limited relevance, it's worth raising now. And I'm particularly concerned that the defense not make the argument that we're for some reason not showing these to the jury. So
Are you okay with that, Mr. Moran?
The argument about the lack of evidence, and that's part of the reasonable doubt.
No, the argument that they're hiding something because this was found by law enforcement and they didn't put it on their case in chief. I mean, I think that's fair to prohibit that, and then you can put in 1093 all you want.
Yeah,
Okay.
hadn't dawned on me.
Okay. All right. So
may I approach, Judge?
yeah, let me hang on to 1105.
Sure.
Actually, these are yours, correct?
Yes, but you can have
Okay,
it.
I'll keep 1105 so it's part of the record, but this one will come in. Okay. Whoops. Sorry, Aaron. With that, are we ready to go?
People are, yes, Your Honor.
Okay. Let's call the jury up.
Excuse me.
Yeah. Or even watch it here.
I can't get him to the big screen.
It's okay. It's just the best we got.
Okay.
Oh, he was there for a second. Okay. Let's just leave it that way then. If it keeps going to the other one,
I think it's just because the
jury needs to see him.
Yeah, it's hard.
Yeah, mine just shows a. Well, as long as it's good here, that's what we want. Well, there's probably other people doing video testimony today. Okay, thank you. And then whenever you want, Aaron, this will be a court exhibit, I guess, or whatever I want to call it. They talked about it. I just thought it should be yours. Okay. Not admitted. Okay. All right. Oh, the other one they're gonna introduce. Yeah, so that'll be fine. That was 1105. long as he shows up there, that's all that matters. Okay, we can be seated. Mr. Bogan, is this your witness?
Yes, Your Honor.
Announce his name, please.
Yes, Mr. Eric Smith.
So, Mr. Smith, I don't think you can see me. I'm Judge Wilson. Could you raise your right hand for us, please? Do you solemnly swear or affirm under penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Okay, are you muted somehow?
He's trying to talk, right?
I do, Your Honor.
Thank you very much. Mr. Bogan.
It pleases the court. Mr. Smith, can you hear me? My name is Justin Bogan, attorney for Mr. Mark Redwine. Over.
Yes, sir, I can hear you.
Can you please state and spell your name for the court reporter in the record, please?
My name is Eric, E-R-I-C-H, Smith, S-M-I-T-H.
And how are you currently employed, sir?
I'm a firearms and tool market examiner at the FBI laboratory in Quantico, Virginia.
How long have you been doing that for?
I've been at the FBI laboratory since 1998, and I was qualified as a firearms and tool marks examiner in 2002.
Can you explain to the jury what it means to be qualified by the FBI as a firearms and tool marks expert?
You have to go through a series of specialized training. It starts off with a manual that outlines all the elements necessary to be competent both in firearms, tool mark identification, and gunshot residue. You actually are assigned to a mentor who's going to guide you through the training. And during the training, you're going to look at what we call known matches, things that were produced by the same tool, and known non-matches, things that were produced by different tools. So you're going to look at hundreds, if not thousands, of comparisons during the training. And at the end of the training, you actually go through a series of tests. 3 are oral boards where other qualified examiners get to test your knowledge, and then 3 moot courts where you are in a courtroom setting similar to this, where you handle evidence and you testify to your results. If you're successful in all those elements, you're qualified by the FBI laboratory.
Does that mean in that capacity as a firearms and tool marks expert that you conduct tool mark analysis on various and sundry items?
That is correct. Actually, you should think of a firearm as just a specialized tool for shooting bullets and exploding cartridges. So firearms is just a subset of tool mark identification.
How many examinations, or how many tool mark examinations do you believe you've done since you've been employed in this capacity at the Federal Bureau of Investigation?
I've done thousands of comparisons. They're too numerous to count.
And I think we'll get into the specifics of this in case you explain one more time briefly what a comparison is. Over.
If you're at my laboratory, there's a series of steps. There's a methodology that we go through. We kind of jump to the end with a comparison. There's a large instrument. It's a comparison microscope. It has 2 stages on it. It allows you to put one specimen on one side and another one on the other side. And an optical bridge allows me to look at the 2 specimens simultaneously. And when I'm looking through the comparison microscope, I am looking for patterns of similarity between the 2 specimens.
And when you talk about analysis, that's what you mean when you say you've done tool mark investigation, is that process. Is that correct?
That is one of the components of the process.
Are you a member of any particular associations regarding tool mark examinations, and could you recite those, please?
Yeah, I'm a member of AFTE, which stands for the Association of Firearm and Tool Mark Examiners. I'm also a member of ENSPI, which is the European Network of Forensic Scientists.
How about the Organization of Scientific Area Committees? Have you had any work or membership with that organization?
Yes, I have. That is an organization that is working to build standards within the forensic community.
Mr. Doherty?
Your Honor, I'm sorry to interrupt. The people would stipulate to Mr. Smith being qualified as an expert in firearm and tool mark analysis and comparison.
Mr. Bogan, is that sufficient?
At this time, we would stipulate and offer Mr. Eric Smith as an expert in tool mark analysis.
Okay, he'll be accepted as an expert in that field.
Thank you, Your Honor.
Now that you've been qualified, Mr. Smith, I'd like you to explain in a little bit more detail exactly what, in layperson terms, tool mark analysis is. You told us about the scopes that you use, but what's the purpose? What are the elements of that kind of investigation?
For our discipline, we have to think of the tool in simple terms. The tool is the harder of two objects. So the harder object comes into contact with the softer object, and it leaves an imperfection behind, which we call a tool mark, which will have sometimes class characteristics of the tool that make contact with it, as well as individual characteristics will help you identify a particular tool.
And does that mean that you're trained in how to identify what kind of tool or what set of tools can leave certain marks on objects?
That is correct.
That training and experience, does that include being able to identify whether bladed instruments or knives can leave specific kinds of marks on objects?
That is correct.
In this case, you were asked to do a tool mark analysis of the partial cranium of Dylan Redwine. Do you recall that?
Yes, sir, I do.
And if necessary, for the purposes of refreshing your recollection, do you have your report on that handy?
I do.
Can you explain for the jury what you did when you received the partial cranium? Was it packaged? What kind of condition was it in? Is basically what I'm asking.
It would have come, and it is recorded as being within a sealed case, and it was delivered.
And what's your initial step? I take it you unpack it, and what's your initial step in unpacking this element?
Right. So now we're actually talking about the methodology for the discipline.
Yes.
So the first component is the evaluation. What is the object that I have in this case? Oftentimes people will send things in, they want a forensic exam, and you just pull it out of the box, and it's not suitable for this particular discipline. So what is it that I have? In this case, it was a piece of bone which happened to be partial skull material.
And you said partially, and then I couldn't hear the last part of your answer. Forgive me.
Skull.
And did you have the opportunity to inspect some marks on the right zygomatic arch of that partial cranium?
I did.
And did you partake in a comparative analysis, and forgive me if I'm not using the right terms, regarding tool marks and those marks on the right zygoma?
I think one of the things you need to understand is in the methodology, so the first step we evaluated was object. But now we're looking at the tool marks. And the first element that we consider are the class characteristics. And class characteristics are anything that are predetermined prior to manufacturing. So for a tool, it might be we're going to make a knife of a certain length and certain dimension, or we're going to make a hammer. It's going to be a ball peen hammer. So the manufacturer has a design. So these are elements that are predetermined and they're measurable features. So they're class characteristics. And one of the other elements that we will try to ascertain is what is the type of action that may have been used by the tool. So was it a sawing type action? Was it a pinching? Did it pliers that might be gripping? These are actual actions that the tool produces. And those are things that we can sometimes glean in the class characteristics. So those are all elements that we categorize up front. And actually at this stage, if I had a tool, and in this case, I did not have a tool, I would be able to possibly eliminate it if the class characteristics were different. But if they're not different, and I had a tool, then there would be the situation where I'd have to do a comparison of the tool to tool marks, suspect tool marks.
And in the first phase of your analysis here, when you're identifying class characteristics of the marks, one of the things you identified was trying to determine what kind of action left those marks. Did I hear you correctly?
That is correct.
And do you also try and determine the size and orientation of these two marks on the right zygoma?
I took some general measurements of the marks and their position.
Do you recall what the size of the marks were?
Can I refer to my notes?
I think that I know that's recorded in your notes by all means.
So for the two marks, I designated them both A and B to delineate between the two marks. And I measured the length of mark A to be 0.09 of an inch long, and the length of mark B, 0.07 of an inch long.
Was that inch or centimeter, sir?
That's in inches.
You also identified what you believed was the kind of action that left these marks. Can you describe that, if you recall, to the jury?
Right. So in examining these marks, these tool marks, I determined them to be produced by a slicing or cutting type action.
After you did the initial assessment of size and orientation and action, what did you do next, observing these two marks on the right zygoma?
At that point, all the data that I can achieve from the examination, I compiled it into my notes, and then I produced a report to my finding.
Did you use any sort of microscope in your analysis of these two marks?
I took a photograph using my comparison microscope just to get a enlarged image of the area that contained the two marks.
And what, if anything, did you learn from that picture you took with a microscope?
Well, that was for documentation purposes only for my notes. I didn't use that to make any determination of the tool marks themselves. That was based on a physical examination, as well as looking at them under a stereo microscope.
Under a what?
Stereo microscope.
Okay. What sort of information did you learn about these marks with the, I think you said stereo microscope,
That's correct.
if I heard correct. What sort of information did you learn about the marks?
The same information that I just relayed, that they are tool marks, very small tool marks, but they're consistent with having been produced by a slicing or cutting action.
And consistent with your training, when you look at tool marks, you can identify striations and different kind of marks within tool marks, correct?
That is correct.
Can you explain why you can do that? And
Well, if we use a tool, in this particular situation, let's pretend that the tool is a knife. If the cutting edge is ground, the grinding of that metal creates individual characteristics, which are encapsulated around the class characteristics of the knife blade. When that tool mark is made and the knife is embedded into a softer object, those individual characteristics are imparted into the tool mark, and you can use those for comparison purposes.
so in layperson terms, does that mean using a microscope, you can look and see if there's a certain kind of striation there or residue or whatnot, and see if that actually matches a particular kind of tool? Am I getting that right?
Right, but in this situation, the two tool marks that are contained within the skull have no microscopic marks of value for comparison. So even if I had a tool to compare to that, there's no individual characteristics that are present for doing that comparison.
And in case it's not obvious to the jury, I am going to ask you to iterate or reiterate, because that sounds like a term of art. No microscopic marks of value. What does that mean exactly?
That means when I'm looking at the actual tool mark, I've already moved past the class characteristics. Now I'm trying to look for what might be impressed features, a defect that might have been present in the tool that's now imparted into the tool mark. As we mentioned before, striated tool marks, marks that look like scratches. For a better use of the term, these are the individual characteristics that we're looking at. So in evaluating any tool mark up front, you're looking at both the class and does it contain any individual characteristics suitable for comparison purposes.
And when you're conducting a tool mark analysis, you can come to 3 different opinions or conclusions. Is that correct?
That is correct.
And those are exclusion, identification, and inconclusive, correct?
That is correct.
Can you explain to the jury what exclusion means?
Exclusion would be if there's a difference in class characteristics. If I have an impression that is a circle, but my tool is rectangular, then I know that this tool did not create that tool. So the class characteristics are different. Inconclusive means that the 2 tool marks are both same in class. They both have circular features, but now the individual characteristics, the striations that I'm comparing, there's insufficient agreement in the individual characteristics that would be consistent what I would have seen with tools that made the same tool mark, or better than the best known non-match that I've ever seen in comparison.
And when you're describing this process and what inconclusive means, you're speaking hypothetically, right?
No, I'm not speaking hypothetically. This is basically how the science works. This is a hypothetical.
Can you explain what identification means to the jury, please?
Identification means all the class characteristics are the same. And now I have agreement in the pattern of individual characteristics, whether it be striations or an impression, that is sufficient to indicate that this is an identification.
Excuse me? Yes.
Sorry, I couldn't hear the last part.
Could you repeat that last answer? Because I couldn't understand it either.
Sure. So when you're comparing 2 items and the patterns, the agreement in the patterns is sufficient in agreement, then you can conclude that this is an identification.
I want to talk about your results of your analysis of the 2 marks on the zygoma in this case. And what were those results?
I reported out the type of action that was utilized to produce the marks, and that there was no microscopic marks of value present within the marks for comparison purposes.
Did you also determine if these marks could be produced by a tool or from environmental exposure?
Right, so in this situation, I didn't have a tool to compare, and I couldn't exclude the possibility that these may have been introduced accidentally in the environment, being that it was found outside.
Well, specifically, your report says it could not be determined if these marks were produced by a tools or from environmental exposure, correct?
That is correct. That is correct.
And could you determine if these marks were even made by the same mechanism?
I could not.
So in your expert opinion, these marks could have been caused by 2 separate tools as you define them, correct?
That is correct.
And can you remind the jury one more time what your definition is of a tool when you're doing this sort of analysis, please?
Right, so the tool is the harder of two objects, and the tool mark is the mark that's left behind when the tool, the harder object, comes in contact with the softer object.
When you were working on this project, did you also have the opportunity to look at what were described as scrape marks above the brow on the cranium as well?
May I check my notes one more time?
By all means.
Yes, I did indicate that there was a scrape mark, but I don't know necessarily the anatomical position of that scrape mark.
And what, if any, conclusion regarding tool mark analysis did you have of those scrape marks?
This particular mark has no class characteristics, so it can't gleam anything, and it had no microscopic marks of value for comparison purposes.
Did this mark above the brow have even less information for you to analyze than the marks on the zygoma?
Yes, sir.
And your analysis of those scrape marks was that you couldn't determine if they were made by a tool or from environmental exposure, correct?
That is correct.
So at the conclusion of your analysis of this cranium, you couldn't determine if any of these marks flowed from a man-made tool or from environmental exposure.
That is correct.
Environmental exposure including possible animal damage.
That is correct.
Nothing further on direct, Judge.
Any cross?
Yes, Your Honor, thank you.
Can you pull the microphone closer to you? Thank you.
Good afternoon, sir.
Good afternoon.
Can you hear me okay?
I sure can.
So, fair to say the FBI lab is accredited and uses best practices in their work?
That is correct. We are accredited.
And when I say accredited, just so the jury's aware, that means you have validated procedures, annual audits, and different steps in place to make sure that your lab is employing rigorous testing and can produce validated results. Is that fair to say?
That is correct.
And you and your lab at the FBI use scientifically sound measures, right?
That is correct.
And I should say thank you for your service as well. You've been with the FBI for how long?
Since 1998.
And in looking over your statement of qualifications, you've worked on many, thousands of cases over the years. Is that right?
Thousands might be a little high, but it's quite a few.
And looking at the cases you list on your statement of qualifications, many of them have been murder cases where you were asked to do a firearms comparison or tool mark comparison, right?
That is correct.
Some of them, fair to say, particularly brutal murders involving firearms?
Yes, that would be fair to say.
And in that work, and I'm going to start to talk about the comparison analysis that you were discussing with defense counsel on direct, but in the work on firearm analysis, part of what you're seeking to do is to compare spent shell casings, bullets, and firearms to one another to see if they match up, right?
If they could be identified to each other or identified to a particular firearm.
Right, so you're trying to see if the spent shell casing left behind after a shooting could be identified as coming from a particular firearm that you're provided for comparison.
That is correct.
Which is why in your line of work or our line of work, there are times where shell casings and firearms are not left behind at the scene. Is that fair to say?
That is true.
Or if someone isn't in our line of work and they watch TV in the movies, they see someone scurrying about taking the shell casings because they don't want anybody to be able to compare the different things that could identify them as having committed the crime.
If I don't have the items to compare them, I can't make any kind of determination.
So, for example, if you don't have the knife or the sharp force instrument, then you don't have a tool to make a comparison to tool marks that you find.
That is correct.
In this case, the FBI was contacted by the La Plata County Sheriff's Office. Am I right?
That is correct.
And the FBI agreed to assist in this manner in a variety of ways, but also the tool mark comparison that you've testified about on direct.
That is correct.
And you generated a report which was provided to the prosecution and then on to the defense counsel, right?
That is correct.
And you met with defense counsel and you met with the prosecution in preparation for this trial.
That is true.
So you and I have spoken before.
Yes, sir, we have.
So I'm going to ask you some questions about your examination of the partial skull of Dylan Redwine, okay?
Sure.
You were asked to look to see whether you could identify injuries that were reported to be located on the root of the right zygomatic arch and examine that for tool marks. Am I right?
That is correct.
And in fact, throughout the course of your career, I believe you testified on direct, you've looked at thousands of different tool marks.
That is correct.
And in this case, when you looked at Dylan's skull, you in fact saw two tool marks in the area of the right zygomatic arch. Am I right?
That is correct.
And by tool marks, what I mean by that is that that's not there naturally. That's not something that's supposed to exist on that part of his skull. Is that fair to say?
That is correct.
And I believe you defined a tool mark as a harder object coming into contact with a softer object.
That is correct.
And the softer object here, Mr. Smith, is actually human bone, right?
That is correct.
So it's going to take a particularly hard object to cut into human bone. Is that fair to say?
Foundation. I think that's a pathological. I think that's a better question for a forensic pathologist about the qualities of bone are and what's harder than it.
Well, I don't know. He may have the ability to do that. I don't know. You can lay a foundation if you want, Mr. Doherty, on that.
Have you seen, thank you, Your Honor. Mr. Smith, have you seen tool mark injuries on human bone throughout your career with the FBI?
Yes, I have.
Fair to say it takes a particularly hard object to cut into human bone in your experience looking at tool mark injuries?
Same objection. Particularly hard is also a vague question.
It is somewhat vague, but I think common experience maybe can talk about. I think it's okay. I mean, he's going to know how much force and what it's going to take in terms of hardness to scratch various items. I think that's part of his expertise. Am I right about that? Is that something that you've studied?
Yes, Your Honor, it is.
Thank you. So go ahead.
Thank you, Your Honor. Mr. Smith, can you answer the question for the jury, please?
In both examination as in research, sometimes I have to actually cut bone material, and it is harder material. It is a hard material, to cut at times.
And in examining Dylan's skull, you were able to observe what you referred to on direct as a slicing, cutting type action.
That is correct.
And it's possible, in your expert opinion, that that slicing, cutting type action was actually inflicted by a tool or cutting instrument. Is that fair to say?
That is true.
Counsel pointed out that in your role as a tool mark analyst, you could not determine if those marks were produced by tools or from environmental exposure. Is that fair?
That is correct.
And as counsel pointed out, you'd want to look to a forensic pathologist for that kind of analysis. Am I right?
That's not what I said. I said a forensic pathologist could speak to the hardness of bone compared to other items.
Right, but I think it's a fair question. So you can answer the question, Mr. Smith.
Could you repeat the question?
That'd be the kind of work a forensic pathologist would do, right?
I would surmise, yes, that is the type of work that they do.
And counsel asked you about wildlife. It's fair to say you have a tremendous amount of expertise, but wildlife is actually outside your area of expertise. Am I right?
That's true. I'm not a wildlife expert.
And for that, you'd want to look at a forensic anthropologist in the state of Colorado. Am I right?
Or an anthropologist in general.
I'm sorry, what'd you say?
An anthropologist in general.
And in addition to the 2 marks that you believe, in your expert opinion, might be from a tool or cutting instrument, you also identified a scrape mark, am I right?
That is correct.
And that's separate than the 2 cuts that you were just discussing, right?
That is correct.
And can you just clarify for the jury where the scrape mark that you identified on Dylan's skull was located, please?
As before, I'm not really sure the anatomical position of the mark as far as its position on the skull.
But it's separate from the, sorry.
It's separate from the other 2 marks, the 2 cutting marks.
Thank you. And 2 mark identification is a empirical science that relies on objective measurements, but also your subjective comparison of the microscopic marks you may find, right?
That is correct.
And I believe you said on direct that you would have to have a tool to compare it to. Is that fair to say?
That is correct.
And in this case, there was no tool or weapon left behind for which you could do your expert comparison.
That is correct.
And just to be clear, when you look, or if you had a tool, Mr. Smith, would
Yes,
you
sir.
attempt to do a mold or a casting so that you could do a comparison between the 2?
There's several different ways that I could attempt to do this examination, one of which would include casting.
Because to be clear, you wouldn't take the knife and start putting it into the bone to see if it matches up, right?
No, we wouldn't do that.
And so you would either need a tool or more context to be able to render a conclusive opinion about whether this was a particular knife or not that was used to inflict the slicing, cutting type action into Dylan's skull.
Assumes facts not in evidence when he refers to what kind of particular knife.
No, it's to determine whether or not. I guess you're right. I understand what you're saying.
Thank you.
Misunderstood. You're going to ask the question again? I think that's easily remediable.
Sure, Your Honor. Thank you. Mr. Smith, you would need a tool for comparison or perhaps more context in order to determine whether a particular knife, saw, weapon, whatever, was used to inflict the slicing, cutting type action that you observed in Dylan's skull.
That is correct.
And when you say context, what would context include?
For me, context would be the 2 marks that are there have very limited information. There is class information, although very, very subtle, but I don't have the individual characteristics that I would need to be able to identify it to a particular tool.
And counsel asked you about the packaging for the skull.
Yes,
Are
sir.
you aware that the cranium was hand delivered by a member of the La Plata County Sheriff's Office in what's called a pelican case for purposes of delivery?
I don't have first-hand knowledge, but my notes indicated it was in a sealed case. It was within a Ziploc bag within a sealed case.
I have nothing further. Thank you very much, sir. Appreciate it.
Redirect?
Yes, please. Now, Mr. Smith, counsel pointed out that you're not an expert in animals. Remember talking about that a few moments ago?
Yes, sir.
As you've also testified, you've been with the FBI doing tool mark analysis for almost 2 decades, safe to say?
Yes, sir.
And you take your analysis and the reports you write very seriously, correct?
Yes, sir.
And you take every word you put in those reports seriously, correct?
Yes, sir.
Including the reports you wrote in this case.
Yes, sir.
And in this case, you said it could not be determined if these were produced by a tool or tools from environmental exposure by an animal, referring to marks A and B. Remember writing that?
Yes, sir.
And you said the same thing about the other scrape marks. Unknown if these were produced by a tool or tools from environmental exposure by an animal. Your word animal, correct?
That is correct.
Nothing further, Judge.
Any questions from the jury? No? Can this witness be excused?
Yes, thank you very much.
Thank you very much, Mr. Smith.
Thank you, Mr. Smith. You're free to go. Ladies and gentlemen, because I'm having computer problems, I want to help the bandwidth through the entire courthouse because this is eating it up with having 2 of these things going. And to get that out of the way, we're going to take a recess. So it won't be very long, but you can go downstairs for a couple minutes and get a drink or whatever you need to do. And Mr. Smith, you're free to go. I thought I said that. Yeah, we need to work on that. You want to go grab Becca so she does what she needs to do? Okay, we'll be in recess until we're ready to go. And then I got to shut everything down, and then I got to read. I lost everything.
Your Honor, how many minutes? Pardon me.
You got 5 or 10. It's going to take us a little while to get all this accomplished. This time I won't start without you. Unless it's a long time.